All right, everyone's here. The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States and this honorable court.
Thank you. The first case on our docket this afternoon is 20-50367, Wilson versus Stroman. Mr. Tittle.
Good afternoon, Your Honors. Thank you, and may it please the court. At the outset, I'd like to indicate how I plan to use the time allotted to me, and that is to address the matters, the points of appeal raised by the appellants, as opposed to the myriad of issues that the defendants are attempting to engage the court in. Obviously, if the court directs me elsewhere, I am prepared to discuss any of the what we have termed the underlying issues. But the district court in this case dismissed on a very specific ground, that being the independent intermediary doctrine as it relates to the grand jury, really a pleading issue at its core, and did not address or rule on any of the other issues. And as this court is well aware, many of those issues are the subject of the appeal that has been briefed and heard in the Terwilliger case. So with respect to the independent intermediary doctrine, I would first like to say that it is not the appellant's desire nor intent to in any way suggest that that doctrine should be overruled. In fact, that is a very long-standing, well-established doctrine within this circuit. And it is simply a matter of viewing this long-standing principle with respect to various intermediaries that can make a determination of probable cause within a criminal process. Of course, the most common is that of the issuance of a warrant in which a magistrate or a district judge or any other judge would view the probable cause affidavit, and that intermediary would then issue a warrant. And if done so, that precludes civil liability according to the independent intermediary doctrine, except in those situations in which the intermediary has been misled or some of the process otherwise tainted. The case law, of course, in this area the vast majority is built up around that particular intermediary, that first step. And we have developed a method for analyzing taint known as a Frank's analysis or a Malley analysis, but those are simply the step-by-step approach that one takes in determining whether the process was tainted in which that intermediary acted. This case, of course, deals with a different intermediary along the chain, that being a grand jury. The process involving the first intermediary, and there are subsequent intermediaries, such as a judge who hears an examining trial. In both of those instances, we have sworn testimony that indicate and give us a very good idea and give a plaintiff a chance to plead how that intermediary may have been misled. Against a backdrop.
I'm going to just interrupt because I think we're pretty familiar with the doctrine behind it. When you said you're not trying to disturb the doctrine, do you know of any other circuit that adopts the doctrine? And I ask because then we could get insight into who has the burden of pleading and with what quantum of evidence to be able to show taint.
Yes.
Are there other circuits that would speak to either issue, especially what quantum is necessary? Because, of course, here the district court relied on Curtis and said it was too speculative.
Right. And as this court, and I realize Judge Higginson, you've been involved in at least, there's a scant number of cases involving grand jury. One was Bueller, but that's a summary judgment case. Winfrey's a summary judgment case. But you were involved with McLennan, which did seem to address, although it was a warrant case, I believe, but it was addressed from an independent intermediary level as opposed to a, quote, Frank's analysis. And in that case, the court said it's a matter of first impression. And of course, the court knows what was said there about mere allegations. As far as other circuits, Your Honor, of course, I think it is implied that the Supreme Court endorses the doctrine as it relates to a Frank's analysis and a Malley analysis. There is certainly a split. I think there's a definite split in circuits as to whether and to the extent that a plaintiff must plead the unknowable at the grand jury level. And I think this circuit, pardon me, go ahead.
Well, you're not asking us in your brief to look at some other circuit for persuasive value. You think McClin is as good as you can get, right?
I think McClin, when read in connection with Winfrey, prescribes the framework that is available to a plaintiff, and really it makes complete sense. It's really the only way that why would the burden be on a defendant at the summary judgment level if a plaintiff can never get past it at the pleading level? And so, yes.
Here's a tough, obviously the companion case is lurking in this case.
Yes.
The Terwilliger case.
Yes.
And then even Malley, I think, is lurking here.
Right.
That may be a little bit of a sophisticated way to approach it, but how are you advising us to either wait for or consider the arguments made in Terwilliger, and does Malley play into the analysis at all?
Thank you. I believe that, of course, it makes the most sense to look at the various intermediaries in a chronological order. If the plaintiff did not get past the intermediary that issued the warrant, either by virtue of a Franks violation or a Malley violation, then it would seem impossible to get past. It would seem like the argument would be over at that point. If the plaintiff does proceed past that, if the independent intermediary doctrine, which really is the reason we have Franks and Malley to begin with, if it says that Malley is okay with the intermediary we call a magistrate, or Franks is okay, then why would we apply a different standard to a grand jury intermediary? They're all making a determination of probable cause.
Oh, I'll probably ask opposing counsel this too, but therefore, do you think we hold this in abeyance for that issue in the other panel?
Well, again, it would seem like to me that there are outcomes of the other case that could affect whether or not this issue needs to be ruled on.
The reason I think this way is, if I apply the Macklin framework, it looks like the Chavez affidavit that we know was given to one intermediary. It might be corroborating evidence if it contains Frank's problems, as your clients allege. But what if the conclusion is what your briefs also suggest, which is it doesn't have PC problems, it has a lack of PC problem. It's a pure Malley defect. Almost every taint intermediary case I find is built on Frank's misdirections. Do you know of any intermediary and taint built on a Malley violation?
I think the answer to that, Your Honor, and this is obviously into the ultimate nuance of these various intermediaries, but the answer to that is yes, Malley. The independent intermediary doctrine itself allows for a plaintiff to demonstrate that there were either misdirections or omissions, things not presented. Misled could include affirmative misrepresentations or omissions. And
but Malley and Franks are not compatible with one another. If it is a Malley violation, you can't have a Franks violation. Sure. So where's the false statement in a Malley defect? You just didn't get there.
I don't think that there would have to, if the court views this as a Malley situation, then ultimately the same logic would apply to the grand jury. We would not be pleading that the grand jury was lied to, but it would be tantamount to if Mr. Reyna, the DA, had just walked into the grand jury and said, or walked to the justice of peace and said, "These are bad people, arrest them." That would be a Malley situation with the warrant. Likewise, if he walked into the grand jury and said, "These are bad people, indict them," that grand jury has also been misled into believing that it's okay to indict. And as we indicated in our brief, the indictment tracks almost to the word the language of the PC affidavit. We believe that the police officers were misled by Mr. Reyna, who indicated—
Where did the district court go wrong? It cited Curtis. Why isn't that, it's just sort of Iqbal Twombly. It's hard to get into the black box of the grand jury, but you need more than you said. Isn't that the logic of the district court opinion?
Where did the district court go wrong? I think the district court ignored the framework set up by McClin. This court, the Fifth Circuit Court, has acknowledged that there is some tension between a plaintiff having to prove something that it occurred in a secret proceeding. Your footnote in McLean actually discusses district court cases that have struggled with this issue. And the district court in this case just ignored the fact, they summarized our 8 pages of facts that were from which you could draw an inference that the intermediary, the grand jury, was misled or omitted. They just ignored that and summarized it in a single bullet point. This was all conclusory. The court went awry by not following the framework set up by McLean. And it cited Curtis v. Soule. Curtis v. Soule actually is a grand jury case that recognizes this precise tension that the plaintiff cannot know the unknowable. Curtis v. Soule is an example, like the 2 or 3 other cases in which the plaintiff attempted to plead taint by just saying there was taint. They didn't even make an attempt to suggest through inference that the grand jury was misled. And I would add, Your Honors, that I am approaching this case with the assumption that what the plaintiffs have pled in this case with respect to tainting or misdirection of a grand jury in this case is the absolute universe of all that they could have pled and could have known at the time of the pleading. The defendants have not, again, 8 pages of everything imaginable. I would argue it is the most detailed complaint ever pled on the issue of taint at a secret, untranscribed proceeding. Now, with that said, and I apologize, Your Honor, I lost my thought momentarily. It's my belief.
Let me ask you a question. You've alleged that Detective Chavez swore to the affidavit and that Special Agent Schwartz testified falsely to the grand jury. What are your allegations, specific allegations against the other defendants?
Well, the other defendants, as we pled throughout our 100-page complaint, they caused or contributed to the process of these false statements, that being that individuals were in a criminal street gang, that they had participated when they did not. All of these individuals participated in the process. The Melton case, which was discussed at length in our previous oral argument, indicates that in a Franks scenario, that is the standard. Did they cause or contribute? And it indicates that any number of defendants can do that. Throughout our brief, we've indicated how these other individuals participated in the process that then led to a grand jury indicting.
I don't know what you mean by that. Participated in the process. You mean in the arrest?
Well, for example, defendants Schwartz and Frost both indicated that people were in criminal street gangs without any knowledge that of one way or the other. It's important to understand in our pleadings with respect to those type of facts, it's not that they looked at something and were simply wrong in how they addressed it. It's simply that they had no idea one way or the other if you, me, or anyone else out there was in a criminal street gang. They just affirmatively said everyone was in one. So that led to this continuation of the process of each other individual. That was their contribution. Mr. Stroman, Chief Stroman's contribution was in failing to advise against probable cause when the only basis was essentially mere presence. He also went along with it and signed off on the arrest. All of those things led up to presentment to the grand jury. But I'll concede, Your Honor, we do not, Mr. Reyna, the former DA, he chose not to transcribe the proceeding. He controlled it completely. We obviously cannot tell you whether Chief Stroman testified in the grand jury or not. But if as a pleading matter, a plaintiff is required to plead with that level of specificity, if there is not some acknowledgement to the fact that it's a secret proceeding, we would submit that it effectively ends any false arrest case in which there's an indictment. There would be no way to ever get past that hurdle, absent a leak. So that would throw the circuit out of agreement with the Supreme Court and many other circuits who say, look, a Franks case is a legitimate thing.
But are you saying you want to get to the discovery stage, and at that point you would show defendant personally but tainting, or are you saying to get the benefit of the independent intermediary doctrine, it doesn't turn on each defendant tainting? Any one taint means there isn't an intermediary.
I think that is the ultimate on the fine edge of the nuance, whether or not, if they were misled by some but not all, whether that taints the process. However, we believe we have adequately pled either a Malley violation against the defendants or a Franks violation, and pushing that on down the track to the grand jury, it would seem to defeat the very purpose of the law if simply by taking it to a secret proceeding and then not transcribing it, you can cleanse everyone from actionable conduct that would otherwise violate constitutional rights. We believe this, and I'm sorry.
You've saved some time, Mr. Tittle, you have saved some time for rebuttal. Your time has expired.
My time has expired. Okay, I didn't see the clock. Thank you, Your Honor.
Mr. Brandt?
May it please the court, Tom Brandt for McLennan County and the former district attorney of McLennan County, Abel Reyna. The district court got it right. The independent intermediary doctrine applies and the taint exception does not. It's hard to establish taint, and it ought to be, but they don't even come close here. In my very limited time with the court, I would like to direct the court's attention to two things. Number one, Chapter 71 of the Texas Penal Code, which provides both the elements of the crime, engaging in organized criminal activity, and the definition of criminal street gang. The second thing I'd like to direct the court to is the plaintiff's complaint, of course, and 8 pages. The 8 pages that plaintiff says is entitled Grand Jury Deliberations Were Tainted. I would like to begin by focusing on paragraph 150 of the complaint, which is found on page 292. In that paragraph, they say, during various examining trials, law enforcement witnesses, including Chavez and Schwartz, have continued to perpetuate the idea that motorcycle club affiliation, jacket and vest patches and other lawful clothing is evidence of membership in a criminal street gang. They then say, the next sentence is, it is reasonable to assume that testimony that they gave at the examining trials was the same thing they testified to in front of the grand jury. And although they can't get it because it's secret, they suppose that's what was done. Now, what's interesting about this, three things are very interesting. First, plaintiffs are claiming that it was false and misleading for law enforcement to testify at examining trials that they inferred gang affiliation by the vests and patches that plaintiffs were wearing. Plaintiffs are trying to convince this court that law enforcement cannot infer anything at all from the fact that a plaintiff is wearing clothing that says, hey, look at me, I'm with the Banditos.
But at paragraph 70, but counsel, paragraph 71, they point out that these articles, clothing, and effects can be purchased online. So that you may have a reasonable suspicion argument, but how could you possibly say it was probable cause of membership if the items they are wearing are available to anyone?
You have to understand in context, these were worn at a particular time and place. They go to the COC&I meeting in Waco there, and they have given an inference, therefore, in the context that they are with the people that they are with, that they are
now, but do you agree also that the Chavez affidavit, if the conclusion of the Terwilliger panel is that the Chavez affidavit tainted the magistrate, then you wouldn't have some separate argument that the grand jury still cures. That's a legal question. But also in the Chavez affidavit, the clothing and effect is not even associated. The magistrate was not told that this is of the Banditos or the Cossacks. It's just that they have common clothing and effect. How does that possibly incriminate anybody?
In the context, the theory was that if you had these criteria, that was what the DA provided, Abel Reyna provided this criteria to law enforcement, then the law enforcement investigated the individuals, asked them questions, and then made determinations. The fact that it didn't make it into every affidavit didn't.
But that's the same affidavit used for 177 people. You say made it into every affidavit. That exact language, not connecting it to Cossacks and Banditos, was associated with every single arrestee, including these plaintiffs, right?
But at the examining trials that they refer to in their own pleadings, that issue was developed in public due process proceedings before a court, determining, yes, probable cause exists.
I don't understand your argument. Are you my first question is, if there was a taint of the magistrate, would there be any case law that would say the grand that isn't enough under Macklin? Or is your argument now entirely turning to these examining trials later? What is your argument?
I'm not turning to that, but what I'm saying is it is not taint. That specific question about patches and vests is not false and misleading. It is a fact. It is a true fact. And that is not, it may be a Malley claim that you're talking about. There's not enough, but it's
okay,
not a
well,
lot.
then that is the question that I was asking opposing counsel. Let's assume that there is nothing incriminating about people wearing clothing and effects when it's not even associated with a particular gang. Therefore, let's assume the affidavit is defective under Malley. Are you saying there's any case law that says that an officer that has Malley liability can nonetheless have the benefit of the independent intermediary because the DA takes the case to the grand jury? Can a grand jury cleanse an unequivocal Malley violation? If so, what's your law?
Well, I don't have any case law that deals with that. I'm representing the DA. I'm not representing Chavez. But so the fact of the matter is there was much more to the presentations in the examining trials, for example. The reason I mention that is because they mentioned that. They actually affirmatively mentioned that as their evidence of taint. Look to the examining trials, they say, see what happened there. And what I'm saying is, yes, a lot happened in the examining trials, and it was more of a full record about the Schwartz and talking about, hey, this is what these signs and symbols mean.
But we don't know what happened in the grand jury, right? Other than that they indicted 150 or 100 plus true bills in one day. So it's not likely many witnesses went in there.
Right.
We just don't know.
That's true.
So why doesn't Macklin require reversal of the district court's ruling, the only thing it ruled on here?
Because there are no allegations of malice, and there's no specific allegations of specific facts that would prove the taint. And so when we go through this, we look at it and say, okay, how is that tainting to say something? Okay, they disagree. They say there's an innocent explanation for why I have a patch. That doesn't cut it under Westby. Just because you claim you're not part of a criminal street gang, you claim you're innocent, that doesn't get you there. They don't have the pleadings. They don't have the pleadings of facts. If they had facts, they could plead them. They don't have.
Judge Owen, may I ask one more question? Chief Judge Owen, may I ask one more question?
Yes.
Okay, well, going with that logic, counsel, let's say the video that they claim your clients had and reviewed before the arrests even, not to mention the indictment. Let's say the video showed that the plaintiffs were members of the Christian bikers gang and that gang actually had been cooperating with the FBI. But the decision was made to not give that video exculpatory to the grand jury so as to allow arresting everyone. That would clearly implicate the taint doctrine, correct?
Well, I'm sorry, but the Christian bikers were not arrested.
I know. If the video showed that the plaintiffs were running or were members of people other than the Cossacks and Banditos, if that allegation of theirs is true, wouldn't that be material exculpatory evidence? No?
No, Your Honor. No, because the engaging statute, if you think about it, it is you're going somewhere for a purpose and you're present there for a purpose of engaging in this organized criminal behavior. Okay, you can duck and cover and get scared and react in self-defense. You're still there. It's not a defense to say, well, when the shooting started and got real hairy, you got scared and you ducked. That's not a defense. That doesn't cut it.
Thank you, counsel.
Thank you.
Okay, thank you. Mr. Mackenzie?
Yes, may it please the court. My name is Alfred Mackenzie, and it's my privilege to represent the city appellees in this consolidated appeal. The principal question before the court is whether the Wilson plaintiffs have pleaded sufficient facts to establish a constitutional violation. In this case, whether they were arrested without probable cause. And that takes me right to the independent intermediary doctrine and Judge Higginson's questions, because there's only one constitutional violation that can be alleged in this case. That's an arrest without probable cause. The question is, how do the plaintiffs get there? They know that the defendants are going to rely upon the independent intermediary doctrine at the warrant stage and at the grand jury stage, which would establish probable cause unless they can overcome that presumption by allegations of taint. And so, Judge Higginson, there aren't separate violations. If there is an alleged Franks violation, I would point the court to this own court's case in Jones versus Perez, whether the court said that there's actually a third question after you determine whether a defendant acted knowingly and recklessly, and that the material omissions or representations actually made a difference to the magistrate's determination. The third question is, did the officer have information establishing probable cause, whether or not the information was included in the warrant? So there may be omissions from a warrant that make that first stage deficient, but when it goes to the grand jury, when we don't know what was said to the grand jury, but we can presume much more was said and shown to the grand jury than was placed in a 2-page affidavit. And by the way, there were 2 days.
Well, wait. I don't know the law that says, I think our law, Winfrey especially, does the opposite. We don't presume there were many other people. And it just so happens here, we do know over 100 people had bills returned against them from a grand jury in one day.
2 days, Your Honor. The plaintiff pleads that was in November of 2015 and January, February of 2016.
But what law do you say we presume there were other witnesses? I thought our law, especially Macklin, acknowledges that we don't know, and you can't have an impossibility situation here. I guess the question to you is, what could a hypothetical plaintiff do to get past the pleading stage? Give me an example of what you would say they need to show.
Your Honor, that example is from your opinion in Bosarge versus Mississippi Bureau of Narcotics. There, the court said that we will not assume the truth of Bosarge's claim that the officers acted intentionally or recklessly in falsely identifying him. How much more wrong can you get? And then the court went on to say, without further allegations regarding the dissimilarities between Bosarge and the man Esom identified, Bosarge has not plausibly established that the identification was unreasonable, let alone reckless or knowingly false. And that's what I always come back to. This is a pleadings case. So I shouldn't say we can presume. That was me speaking, not that the court ought to. But the plaintiffs haven't pleaded sufficient facts to infer the opposite. Let me give you some examples. When Mr. Tittle says that they've pleaded the universe of what they could plead, they don't, for example, go beyond a conclusory allegation of we were not a member of a criminal street gang. They simply say that we were not guilty. If a plaintiff can simply plead innocence in every civil rights case, there would be no independent intermediary doctrine. And so what would they need to plead? They would need to plead specifically, as Judge Higginson suggested, we were actually wearing the colors of the Christian biker gang. And what the DA said is go arrest everyone who is associated with the Banditos or the Cossacks. And we know that some plaintiffs, like Harper, have admitted that they were a Cossack, and that other plaintiffs have alleged that they were members of clubs that were affiliated with the Cossacks and the Banditos. And in Portillo, this court recognized the support role of the affiliated clubs trying to reach full membership in the Banditos and the Cossacks. The court acknowledged that violent altercations occurred between those 2 motorcycle clubs at the same time as the Twin Peaks battle. And specifically, in answer to the question about patches being available for public purchase, the court recognized that Banditos violently confiscated patches worn by disloyal members. Not just anyone could wear a Bandito rocker. And if you're a member of a support club, there were certain ways that it had to be worn. What did the plaintiffs' pleadings say about this? Excuse me. They say,
well, while you're taking a drink, you mentioned my Bosarge decision, and I'm almost embarrassed when I don't remember my own cases. Is that a case you cited in your brief or not?
yes, it is, Your Honor.
Okay.
And so what did the plaintiffs plead? They plead that Jeffrey Rogers was a gang investigator, that he also gained information from the two DPS officers who were providing information on the rivalry between these two gangs. And so if you look at it from the perspective of an objectively reasonable officer, we really need to give the officer the benefit of what would an objectively reasonable officer do based on the facts pleaded by the plaintiffs. And the plaintiffs are saying they investigated these gangs. They knew there was going to be a battle. They knew what kinds of colors they would be wearing. The DA is pleaded in the complaint, specifically said, you can arrest everyone who is wearing the colors of the Banditos or the Cossacks or their affiliates. And then the plaintiffs plead that's exactly what was done, according to the testimony of Sergeant Price. And so it's the plaintiffs' pleadings that put into evidence probable cause that a reasonable officer could believe if you're present on the scene of this type of violent confrontation under the totality of the circumstances, and you're wearing the colors of a criminal street gang. And the second element.
That may justify putting him in the arena to begin with, but we're looking at whether a grand jury was or wasn't tainted days later. So what specifically is your argument on the issue that the district court decided here, as opposed to reasonableness and qualified immunity?
Well, and that's exactly what the district court said, is that all of those 8 pages of allegations were conclusory. We aren't guilty, or we ran and ducked for cover. That's not material. That they weren't proven to be members of a criminal street gang because they weren't on the database. Again, that's not the quintessence non of being a member of a criminal street gang. And then Schwartz testified that they were present in a show of force, and that's in the plaintiff's pleadings, which supports the inference of conspiracy. I see my time has expired, Your Honor.
Thank you, Mr. Mackenzie. Ms. Thompson.
Thank you, Chief Judge Owen. May it please the court, I'd like to focus on 2 separate problems with the plaintiff's claims against the DPS special agents Schwartz and Frost. Even if the court disagrees about the independent intermediary doctrine and the burden to show taint, the claims against these defendants must be dismissed for independent reasons. The first problem with the plaintiff's theory is their failure to allege any facts that would plausibly connect the special agents with the plaintiff's arrests. And the second problem is their failure to identify clearly established law showing that probable cause was lacking. For both of these reasons, the court should affirm the reasoning or the judgment of the district court. I'll turn first to the allegations against Schwartz and Frost. The plaintiffs don't identify the Schwartz and Frost as signing the affidavit, and they don't identify them as providing any particular facts for inclusion in the affidavit. So both Malley and Frank's liability can't lie against these agents. Indeed, the plaintiffs identify other law enforcement officers and the DA as having participated in the process. They say that the DPS agents participated, but they don't show how. And that doesn't satisfy federal pleading standards. At ROA 275, the plaintiffs say that it's the DA's office that decided that these facts would create probable cause. Then they say that the Waco police detectives prepared the warrant affidavit. That's at ROA 279 and 280. Then they say that Waco police detectives applied the DA's predetermined criteria. That's at ROA 275 as well. Of course, they identify Officer Chavez as signing the affidavit, and they also omit the DPS agents from the list of the people who knew what the wording of the affidavit was going to be. That's at ROA 282. That forecloses Malley liability. And even if we assume arguendo that there were false statements in the affidavit, without any facts connecting Schwartz and Frost to that affidavit, there cannot be a claim against them under Frank's either. Now, to be sure, the plaintiffs do include all of the defendants in a few lists. For instance, at ROA 277, they say all of the defendants caused warrants to issue. And at ROA 281 to 82, they say all of the defendants made misrepresentations. Well, those are the kind of threadbare assertions that are not entitled to a presumption of truth. Those are just the elements of a Franks claim. And recitations of the elements of the cause of action, of course, do not suffice as well-pleaded facts. So even if the court disagrees with the defendants on everything else, the claims against Agent Schwartz and Frost should be dismissed. Now, I'll turn to the bigger picture issue of qualified immunity here. The discussion that has previously gone on doesn't even need to be addressed by the court if the court agrees that there's no clearly established law showing a Fourth Amendment violation. And
but Ms. Thompson, I mean, the clearly established law here is Malley and Franks. So you're right. To me, it looks like it's a connection issue, which we wrestled with in Melton as to Malley. I think it's a little more subtle and difficult as to Franks. But my question to you is, the district court didn't do any of this parsing. You may be right, but why would we reach it? And related to that, are you defending the dismissal as to your clients on the ground that the district court ruled on, or are you making separate arguments that we would have a basis to affirm differently on?
Your Honor, I hear two questions, and I would like to clarify one of the premises of those questions. I'll just go backwards. Yes, we do defend the district court's judgment. We agree that the independent intermediary doctrine applies here. The second question has to do with, and I'm already blanking on what it is.
Well, I think it is. I mean, you're defending that, and you're absolutely right to use most of your time on a separate ground. Having heard my questions to both counsel before, would you want to add anything as to the narrow ruling the district court made here? Particularly, is it in conformity with Macklin?
Your Honor, on Macklin, I would submit to the court that there is no, that the question of what kind of specificity in the allegations about what was presented to the grand jury was not squarely before the court in that case. I've looked briefly at the briefs in the case. Your Honor, of course, knows the case better, but as I read it, the parties' dispute was about whether there was a seizure at all. And
right, but in footnote three is pretty extensive about how a district court would rarely resolve the taint issue at the motion to dismiss stage.
Very well. I take the plaintiff's argument from Macklin to be that its example of what factual pleading suffices to show taint is a holding of the court. And I would dispute that. That was not the ground on which the court decided the case. And neither is the footnote, of course. And so it's not binding on the court to use the Macklin example as this.
What about Winfrey? I mean, this is helpful to me, but in your few minutes seconds left, what about Winfrey? Do you accept the case and distinguish it, or do you think it is not consistent with the rule of orderliness?
I don't think it's consistent with the rule of orderliness. The burden has always been on the plaintiff to show taint. And I just want to back up briefly. One of the premises of your earlier question, Judge Higginson, was that Franks and Malley are the clearly established law. We disagree with that. If I might finish the answer to my question, Judge Owen.
Yes.
Thank you. That is not the level of generality at which qualified immunity is decided. There needs to be a showing that the officer should have known, in light of the particular conduct at issue, that their conduct was unlawful. And the plaintiffs haven't even attempted to identify a case dealing with anything factually or even legally analogous here that could have provided fair notice. Thank you, Your Honor.
Thank you. Ms. Englehart, would you add 2 minutes of time to Mr. Tittle's rebuttal time? Thank you.
Thank you, Your Honors. I'd like to start with the comments made by counsel for DPS. Counsel for DPS was not involved in the Terwilliger oral argument and appeal. And they were not involved for the very simple reason that when the district court denied their motions to dismiss on Franks and Malley, our allegations of Franks and Malley, and the court ruled in that case that we had a Franks case, the DPS defendants chose not to appeal those. So now Ms. Thompson is trying to essentially make arguments about clearly established law that could have been made in the Terwilliger case, but for the fact that the DPS defendants chose not to join in on that appeal. Now, with respect to a couple of the comments that were made, and then I would like to just end by talking about McClellan. The defendants are effectively arguing, they've yet to answer the question, if you adequately plead either a Franks or Malley violation, in other words, that the intermediary at that level was tainted, that process was tainted, can a plaintiff then, can the defendants then simply rely on the secrecy of the grand jury proceedings to say, hey, it's secret, anything you pleaded speculation, we win? That is, we said that was their argument in the brief, and today I've sat and listened, that is still their argument. Mr. Brandt has argued that if they were wearing some kind of colors, that would be enough. But that's essentially the same thing that was discussed in the Terwilliger case. But he says, well, if the defendants were, if they were present, Your Honor, presence alone doesn't get you there. They have alleged a vast conspiracy among hundreds of people to commit capital murder. I would suggest to this court that whether or not an individual was a member of a criminal street gang, that fact, that one fact, even if it were true, and we clearly deny it in our pleadings, from that one fact, you would certainly not be able to infer a conspiracy to commit capital murder.
Well, wait a minute. When you say you clearly deny that your clients were members of the Cossacks or the Bandidos, Texas's brief at least argues the opposite, saying that you actually have conceded there were. What would help me would be a citation to the paragraph where you actually deny the plaintiffs were members of those two criminal street gangs.
We denied repeatedly that each individual plaintiff was a member of a criminal street gang.
No, I know, but do you ever deny that they were members of the Cossacks or the Bandidos?
I don't know. With a number of the plaintiffs, they specifically say we were a member of an independent club that was not affiliated in any manner with the Cossacks or Bandidos. Now,
stop right there. If you could point me to the paragraph where, as to these plaintiffs, the 100 or so here, right, any one of them has denied that they were affiliated with those two.
Okay, could I do that after argument?
Yeah, of course.
I don't think I have it at my fingertips right now, but in the final few minutes, I would say that what the defendants, the city and the county are doing, they're still arguing just whether it's a Franks or Malley violation. If we back up to what this appeal is about and the 30,000 foot level, McClellan or Macklin, however it's pronounced, I would like to say this. I wondered, why is the court calling this a case of first impression? It's a warrant case. I've read hundreds of warrant cases, and in warrant cases, the court says, was the magistrate misled? Was there a lie? Was there a misrepresentation? What was the mens rea? It's a Franks analysis. So I kept thinking, why is the court calling this a matter? And it's not. And McClellan was not a grand jury case. It was a warrant case. But it dawned on me that the court simply addressed the issue as you would do under the independent intermediary doctrine, looking at it could be any intermediary in the process. It doesn't have to be, just because we normally look at the magistrate, the independent intermediary doctrine applies to all of the various intermediaries. And the court in McClellan was recognizing that with certain intermediaries, particularly the grand jury, as it noted in the footnote, we have to connect with reality. At some point, Iqbal and Twombly have a violent head-on collision with reality as it relates to the secrecy of a grand jury proceeding. To answer your question, Your Honor, yes, we believe we have adequately pled a case that indicates that all of the various intermediaries were misled, and we should be allowed to conduct discovery. Perhaps summary judgment will show something different. But I will say in closing about the examining trial reference, an examining trial is a hearing to determine whether there is probable cause to hold a particular individual. Any examining trial that might have occurred might have some probative value or some relevance as to how that intermediary was misled as it relates to that individual. But the defendants are trying to use the fact that a single examining trial or two examining trials out of hundreds occurred to determine if a certain person if probable cause existed for a certain person, to extrapolate out that therefore all of the facts and material facts were presented with all of these plaintiffs that make up all of these cases. It is important to note that we have pled that any number of these people were nowhere near the incident. They were pulling up, they were hundreds, 400 or 500 yards away, that nothing whatsoever to do with anything. They simply dove behind a car. The video evidence would show very clearly that these plaintiffs that are part of these lawsuits had no participation, no active participation. It would be incumbent at some point for the defendants to demonstrate how they conspired. They've not done so. Yes, Your Honor.
Could you have pled the Malley dismissal or not? Could you have appealed it, I mean?
Pardon me, are we talking about
on Malley's, because the court dismissed Malley, right?
On this case?
No, in Terwilliger.
I think the court, the court ruled that because it was affirming, no, I don't believe we could not appeal Malley. It wasn't a final judgment. It was, the court did not dismiss our cases. They affirmed, or I'm using the incorrect language, they denied the defendant's motions to dismiss our Fourth Amendment claims and called it a Franks claim. Yeah. They appealed that. The Malley claim is simply not, has never been, there's no judgment on that issue. And as we mentioned there, the court can affirm the trial court's determination on any number of grounds.
All right, thank you.
Thank you, Counsel. We have your argument. For those of you who are in the next case, will you just stay on Zoom and we will add the additional lawyers?